Greetings everyone, my name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com, and today, after a somewhat extended and mostly unplanned hiatus, in which saw me appear on the Dr. Drew Show, go like 3 days without sleep because Melania Trump plagiarized, and a bunch of other crazy stuff, I am back and very, very excited to be here. And to make amends for the extended time away, I want to start off by discussing and trying to break down the most requested case on this channel, the Oracle v. Google lawsuit. Now, I have previously kind of shied away from this a little bit, the reason being I know that this is a very technically and legally complex case with a lot to go through and break down, and some of the stuff I'm not the most qualified in the role to discuss, especially some of the technical stuff, so I've leaned heavily on some of my programmer friends and family to try to make better sense of this. Regardless, we're going to try to go through this entire case in this video. I have no idea how long it's going to be other than long, but still, we're going to try to do exactly that. Now, before we dive in, we have to understand two things, or have two conversations at the very least. First, we have to talk briefly about what is a programming language, and second, what qualifies a work for copyrightability in the United States. Now, the issue of a programming language is important because this case deals with the APIs to Java. Now, any programming language you work in, pretty much, with only, like, I guess assembly is like the exception here, but whether it's C++, it's Java, it's, anything like that, doesn't matter, your computer can't read that language. Has no idea what you just wrote. What you wrote is known as source code, and that source code has to be taken through something, whether it's, a compiler or an interpreter, that would then spit out object code. And that object code is what your computer can actually run. So every programming language has two parts. First, it has that compiler or interpreter, or that mess in the back end. And different languages do it through different means. But it's a mess of code on the back end that takes the source code and converts it into something your system can understand. And you have an API that teaches you how to interact with that code. Now, it's not always called an API, but it's functionally very similar. It's a set of instructions for how to write in that language. And like I said, this case centers around the Java API, meaning the Java instructions for how to create a Java app. And we'll get into why in just 1 minute. Now, the issue of copyrightability is a little bit different. You see, in the United States, for a work to have copyright protections, it has to have two things going for it. First, it has to be a work of requisite level of creativity, which that level is incredibly low, and it then has to be fixed into a tangible medium of expression, and pretty much anything physical can be a tangible medium of expression. It could be a hard drive, a scribble on a napkin, just about anything. Anything that's not merely an idea rattling around in your brain. So that's pretty important because of this case here from 1991. It's Vice Publications v. Rural Telephone Service. Now, in this case, Rural Telephone Service was a very rural, I believe it was Kansas, telephone company that was obligated under the law to produce a directory. However, they declined to give Vice Publications, a company that makes much larger, much more varied directories, access to their list. However, Feist, being a publication that wanted access to Rural Telephone Service's 4,000 odd customers, did so without permission. And this resulted in a copyright infringement lawsuit because up to this point, the sweat of the brow was the same. That means if you worked really hard on something, you would have copyright protection in it, no matter how uncreative it was. Well, not true in this case. The Supreme Court in 1991 ruled the sweat of the brow does not apply, and since a phone book doesn't really have any creativity, it's just a list of names and numbers, i.e. factual information, in a non-creative order, i.e. alphabetical, no copyrightability exists. So no creativity, no copyrightability. Bada bing boom, we're done, right? Well, not exactly. Because I can still take that phone book and let's say I make a top 20 list of the weirdest names, or the top 10 funny phone numbers, or I don't know, I'm really stretching here, but I make some kind of creative list out of it. I don't own the copyright to that factual information, obviously, but I do own the copyright to the structure, sequence, and operation upon which I put that factual information in. You can still hold copyright over factual information so long as it's organized and interpreted in a way that is indeed creative. Now, this brings us full circle to talking about this case. Here we have the initial complaint that Oracle filed against Google. The long shot of what happened is when Google was working on building its Android operating system, they wanted to include Java, and the reasons are pretty obvious. They were getting ready to launch essentially a new operating system, and if it had Java and the ability to run Java apps, well, guess what? You've already got all these Java developers out there who can quickly either write apps for it or maybe even convert some of their apps to work on Android out of the box. Remember, they were coming up from behind here. They were having to compete with iOS, which had been in the market for a few years. This was a way to get a leg up on getting developers involved in Android. However, the two parties could not reach a deal. And actually, Google was initially negotiating with Sun Microsystems, which Oracle bought, but, separate issue. Anyways, Google decided to basically take those Java APIs, remember the instructions for how to program a Java app, and then rewrite all of that code that does the parsing and converting source code into object code themselves. They did that in a clean room environment to ensure that no Oracle-owned code would make it in there. Yet the APIs remained the same, because if those APIs were not the same, then Java apps would not work. Now, Oracle, as you saw there, sued, claiming copyright infringement. They also claim patent infringement. What we're not doing the patent stuff. No, ain't nobody got time for that. Okay, we're not, screw patent law. Screw it so hard. I'm sorry. I have bad dreams still about the times I've tried to deal with patent law. Now, Oracle, to make its case, had to make two separate arguments. First, they had to prove that that their API, or at least the structure, sequence, and operation of it, was indeed copyrightable. And if that was the case, then they had to prove that Google actually committed copyright infringement by using it. Two separate issues. A lot of two separate things in this. Anyways, here is an example from the Java API. And if you squint and you look at it a little bit, you can kind of pretend that it's not code we're looking at, and you can imagine it and perceive it as a phone book. It's got a name, it's got what that name does and how to use it. It's seemingly a list of factual information. However, Oracle was arguing that the way this information was created, organized, and packaged and presented deserved copyright protection. Well, this is where the thing gets a little bit seemingly out of order. You see, the case went to a jury trial, and the jury was instructed to assume that the structure, sequence, and operation was indeed copyrightable, and then they proceeded to get hung. The first jury to receive this case got hung on the issue of fair use, could not reach a verdict, and that effectively seemed to bring the case to a dead end. But after doing so, the judge, in this ruling here, ruled that the structure, sequence, and operation of the code, of the API rather, was not copyrightable. Now, it might seem a little bit peculiar for the judge to rule on copyrightability after the jury failed to reach a fair use verdict, but the reason for doing this was pretty sound. The judge really wanted to make sure this case was appeal-proof, if you will. So the idea was this: if the jury's instructed to assume it is copyrightable and it comes back with a verdict, it doesn't really matter which way it goes, and then he rules that it's not copyrightable, and then he gets overruled on appeal, well, the appeals court will probably just reinstate the jury verdict, and there's no need for a second trial. Everyone saves time, the court doesn't have to deal with this hassle anymore, bada bing, everyone's happy. Unfortunately for him, he didn't bet on the jury getting hung. So when he issued this ruling, the matter went up to the appellate court, and the appellate court overruled Judge Alsop in this case. The appellate court basically said, look, this is indeed copyrightable. And it's easy to see why there's some disagreement here when you look at what is in an API. In some ways it definitely is a lot like a phone directory and so forth. In some ways it's not. In some ways it's more creative, in some ways it's less creative. It's very, very interesting discussion here. And I don't think there's really a right or wrong answer here. But with the appellate court having spoken and the Supreme Court refusing to take the case, the standing in the United States is that APIs, their structure, sequence, and operation at the very least, are indeed copyrightable. Now that kicked the matter back down to the lower court, where a new jury picked it up, and this time they did come back with a verdict, and they ruled that it was a fair use, meaning that there was no infringement. Remember, fair use, as we discussed previously, is an affirmative defense in which, in this case, Google is trying to present to show that, yes, they did copy copyrighted work, but it wasn't an infringement because it was a fair use under the law. Now, this brings us to sort of where we are now. Both sides are actually appealing, the last I checked, so we're probably going to have at least the appellate court take one more look, but the odds of the appellate court doing anything drastic are pretty unlikely here, and the reason is simple. When the judge issued his ruling on, and I'll put up the Alsop ruling again, it was a conclusion of law. You can actually see it there toward the bottom of the paragraph that's captured in the screenshot. He said it was a conclusion of law, not a conclusion of fact. Juries create conclusions of fact. Oops, sorry about that. The long and short of it is this. Appeals courts do not like, if they can avoid it, overruling juries. I mean, why have juries if the appellate court is going to call them stupid poopy heads and overrule them willy-nilly? It doesn't make sense. Why have juries at all if the appellate court just simply knows better? They're not going to say the jury was wrong, not likely at least. Instead, there's going to be some proof that something was wrong with the jury. The jury was tainted. They got bad instructions. They saw evidence they shouldn't have seen. They were otherwise, maligned against Oracle in this case. And if they can show that, then there's a decent chance at another trial. But if they can't, it's unlikely that this verdict is going to change. So what does this verdict mean? Well, it depends on who you are and how you feel about this. But most of my friends that have been thinking about this are open source developers to one degree or another. And to those, I say this is a mixed deal. You see, if the court had ruled that APIs were not copyrightable, then that would be a blanket ruling. We would know that, for all eternity, pretty much, at least until another court came along and said something different. But we would just know this. And every time that you were accused of copyright infringement for using an API, you just wave the ruling in the face and be done. Be pretty much the end of it. A fair use case, as we've discussed in the previous videos, is an affirmative defense. That affirmative defense means it can be applied differently. You take these exact same facts to a different court, to a different judge, to a different jury, you might get very different results. There's a lot less certainty. So while yes, Google did win, and those who want to copy APIs certainly have a little reason to celebrate, it's not a definitive victory. There's no guarantee that if you copied an API in a fashion even similar to what Google did, you would emerge victorious in a case were you to be sued. So long and short of it is, this kind of puts the idea of APIs in a weird gray zone. You see, yes, APIs are copyrightable, but what Google did was probably one of the most quote-unquote egregious types of copying an API. They copied the entirety of the API to sort of make their own version of the same language. It's really kind of a peak amount of egregiousness, if you will. And it was found to be a fair use. So yes, they're copyrightable, but when will copying an API not be a fair use? That's a tough question that I don't have an easy answer to. But still, it doesn't provide a great deal of certainty. So that's kind of where we sit, is that if you're an API author and you want to protect your APIs, this greatly weakens the copyright protection you have. But if you're someone who wants to use an API, you don't have a lot of legal certainty because of the nature of fair use. So there you go. Kind of stuck in limbo on this issue. I don't know, we'll definitely be watching to see what the appeals court does with this. I personally don't think they're going to do anything too drastic, as I said, but never bet on litigation. That is one of my rules, because anything can and probably will happen. Well, on that note, everyone, I hope this case makes at least a little bit more sense now. I apologize for the length of the video, but I will be back. We got more updates on the various YouTube lawsuits going on, so until next time, this is Jonathan Bailey, signing off.